Hello. If you're studying contracts for your CIPS exams, then one of the core concepts you need to understand is the relative importance of contractual clauses. Now, CIPS does not stipulate which legal system it's referring to in its syllabus, and there are differences across the various legal systems of the world when it comes to contract law. However, in general, you could make the assumption that CIPS is focusing on the principles of English law despite being an international qualification. So in this session, we're going to consider the two main types of clause and what makes them different. Let's start with the most general of contractual clause. These are referred to as warranties. In effect, they form a set of promises between the parties of the contract. Examples of warranties include the general terms of supply, as well as any clause associated with non-performance, such as liability, indemnity, or insurance clauses. These warranties form part of the overall obligations and promises underpinning any contract, such that in the event of breach, the affected party has the right to demand compensatory damages for any losses incurred. In law, this is referred to as an equitable remedy. You break a promise to another party, you're therefore liable to place them back into a situation where there's no longer any loss. In general terms, most clauses in a contract are warranties. However, there is another higher and more important category of contractual clause referred to as conditions. Conditions are considered to be so important they go to the very heart of the contract itself. If one party was to breach one of these types of clause, it would be like breaking the whole of the contract itself. Here, for this type of clause, the payment of compensation is not considered to be sufficient. Or to put this into legal terms, the payment of damages is not considered to be a sufficiently equitable remedy. So in the event that a condition is breached, a court will determine the very contract itself has been broken, and the injured party is given the right of repudiation as well as the right of compensatory damages for loss. Now, at this point, the injured party is therefore handed a decision as to whether they wish to continue with the contract, that is, to affirm the contract, or whether they wish the contract to end. This right of repudiation will be viewed in different lights depending on what the situation is. It's possible that the other party has so badly affected the contract that you'll want to exercise your rights to cancel the contract and find someone else to conclude it. However, in another scenario, you might want to compel the other party to continue to fulfill the contractual obligations. And so we have two, and only two, classes of contractual clause. Now, in some contracts, it's explicitly spelled out whether a clause is a condition or a warranty. A time is of the essence clause is a great example of how a clause can be constructed to say that timeliness is so important it forms the very essence of the contract itself, a clear condition. However, it's often the case that lawyers do not stipulate whether a clause is either a condition or a warranty. These unnamed clauses are referred to as innominate clauses. The lawyers are deliberately leaving the clause undetermined so that a court can make a ruling depending on the circumstances of any breach. In these cases, the court ultimately decides whether the clause should be construed as a condition and go straight to the heart of the contract or as a warranty. So let's just summarise. We've seen there are two classifications of contractual clause based on their level of importance. Conditions are considered to be so important they are the essence of the contract itself. This means that a breach of any such condition gives the injured party the right to repudiate the contract and also to claim for damages. Whereas all other clauses are warranties, and while of some importance, they don't constitute the very heart of the contract. And so that if breached, the injured party can only claim damages for loss. So I hope you found this summary useful for your CIPS exams. Please do remember to like this video and to subscribe to our channel for more CIPS exam revision tips. And most of all, thanks for watching.